Good afternoon, everyone. It is my great pleasure to welcome you to the grand final of the competition. And so I will just do the announcement and yield the floor to the chairperson. So the WTO dispute in the case Versania, seizures of vaccines, is now in session. The chairperson of the bench is Mr. Peter van der Bosch, and I yield the floor to him to introduce himself and the other panelists.
Thank you very much, and indeed, welcome to this hearing in Versania, seizure of vaccines in transit from Arion. My name is Peter van den Bossen, and I'm Director of Studies of the World Trade Institute in Bern, and formerly chair and member of the appellate body. It is my great pleasure to be the chair of a panel that will judge the two finalists today. And I will ask each of the panelists to briefly introduce themselves. And perhaps I'll start with Tatiana.
Thank you very much, Peter. Good afternoon. My name is Tatiana Payosova. I'm a senior associate at Van Balen-Bellis Geneva office.
Good afternoon. Anthony Taubman is my name. I'm director of the Intellectual Property Division here in the WTO. I was sitting in exactly this seat 2 days ago during the TRIPS Council, and I can guarantee this afternoon will be much more entertaining and interesting.
Good afternoon. My name is Pramiti Parvani. I'm the case author of this year's case, and I'm currently doing my PhD at the University of Amsterdam. I'm looking forward to seeing the arguments today.
My name is Lothar Ehring. I work as a senior expert in the European Commission, the Directorate General for Trade, the unit that is responsible for dispute settlement and legal aspects of trade policy, and where transit has always been one of my favorite subjects.
Good afternoon. I'm Dina Badrai. I'm a Deputy Senior State Counsel from the Attorney General's Chambers in Singapore. I work in the International Affairs Division. My area of practice is generally public international law, mainly international trade and also human rights.
Good afternoon, everyone. My name is Victor Crochet, and I work as an associate at Van Balen-Bellis together with Tatiana, and I'm also a member of the academic board of the competition.
Oh. I think it's now clear to both parties that you have a formidable panel that will be judging you. I'd like to start this competition by, first of all, giving the floor to the complainant for a brief introduction, and then followed by the respondent, again, for a brief introduction of the teams. Please, go ahead.
Members of the panel, good afternoon. My name is Nicole Teo, and here with me today are my co-counsels, Mr. Sean Rapa, Mr. William Chung, and Ms. Zhang Yueying, who represent the complainant in this case, Arion. Now, members of the panel, this case concerns the seizure and destruction of COVID-19 vaccines produced under a compulsory license known as Executive Order 46. The seizure and destruction is subject to 3 main claims under the TRIPS, the GATT, and the 2022 ministerial decision. We submit that the 2022 ministerial decision is the crux of this case, because if the vaccines were lawful as such, their exportation should not have been inhibited. As such, I will spend 21 minutes showing you that the vaccines were lawful under the 2022 ministerial decision, and therefore Executive Order 46 was a valid compulsory license. I will also show that as a result, under paragraph 3C, the seizure of the vaccines was prohibited importation. Mr. Rapa will speak for 24 minutes on the TRIPS and GATT claims. Under TRIPS Article 41.1, he will show that as the vaccines were lawful, they constitute legitimate trade for which the seizure and destruction was a barrier. He will also show that there was a violation of TRIPS Articles 51 and 52, as Versania has failed to consider that the vaccines were lawful under Bhutan law. Finally, under GATT Article 5.2, as the vaccines were lawful, they constitute traffic in transit for which the freedom must be guaranteed, and the seizure and destruction was an inhibition of such freedom. We reserve 5 minutes for rebuttals, which I shall be doing, and my co-counsels, Ms. Zhang and Mr. Cheng, will not be speaking today. Thank you.
Thank you. I will now hear from the respondent.
Good afternoon, distinguished panelists, counsel for the complainant. My name is Jana Kim, and together with my co-counsels, Ms. Wang Lebo and Mr. Ian Chesney, we represent the respondent in this matter, the government of Versania, and we will be responding to the 3 claims raised by the complainant before the panel. First, I will address the panel's lack of jurisdiction to hear a violation claim of the 2022 ministerial decision on the TRIPS agreement, as it is not a covered agreement under Article 1 of the DSU. If the panel deems it appropriate to exercise its jurisdiction, Versania meets its obligations under paragraph 3C of the decision. Second, Ms. Wang Lebo will address Versania's seizure of patent infringing vaccines, which is consistent with Articles 41.1, 51, and 52 of the TRIPS agreement. Lastly, Mr. Chesney will address Versania's consistent measures under GATT Article 5.2, as freedom of transit is not provided to goods that fail to comply with Versania's applicable customs laws or regulation. If seizure is deemed inconsistent, it is justifiable under GATT Article 20D. Regarding our speaking time allocations, I will present for 14 minutes, Ms. Wang Lebo for 14 minutes, and Mr. Chesney for 17 minutes for a total of 45 minutes. And with the panel's permission, Ms. Wang Lebo will present our 5-minute rebuttal. Thank you very much.
Thank you. I turn to the timekeepers to ask whether there's any comment that they need to make at this point.
Only that the time, the appearance sheets are in order what was presented right now, and maybe that the teams are can require up to 2 minutes of the additional time per person. And that time is then added to the respondents and can be divided however the respondents prefer.
Thank you. Right, so I think we're ready to start. I'm happy to give the floor to the complainants.
Thank you, Mr. Chair. Members of the panel, this case concerns the seizure and destruction of COVID-19 vaccines produced under a compulsory license known as Executive Order 46. Executive Order 46 was issued in July last year when we saw a global resurgence in the number of COVID-19 cases, despite the fact that more than half the world were considered fully inoculated. It was in this context that Executive Order 46 was issued. The heart of this case is the validity of Executive Order 46 under the 2022 ministerial decision. It follows that if the vaccines are lawful, their exportation should not have been inhibited. And if the vaccines could save lives, they should not have been destroyed. Let me first explain to you how the 2022 ministerial decision functions. Now, members of the panel, ordinarily a compulsory license must comply with the entirety of TRIPS Article 31 to be
Counsel, I think, can you just get us to the gist? Do we have jurisdiction to listen to you with regards to the MC12 decision?
Madam Panelist, we do submit that this panel has jurisdiction to consider the 2022 ministerial decision because it is a subsequent agreement to the TRIPS agreement, which is a covered agreement. In paragraph 1 of the 2022 ministerial decision, it explicitly refers to TRIPS articles 28 and 31. As such, the 2022 ministerial decision.
Council. A subsequent agreement. I assume that you get that concept from Article 31(3)(a) of the Vienna Convention. Now, does a subsequent agreement become a covered agreement within the meaning of the DSU?
Mr. Panelist, we submit that in this case, it must come under the jurisdiction of this panel, because if it does not come under the jurisdiction of this panel, the 2022 ministerial decision is systemically unenforceable, which would render it unable to be used by countries like Arion to issue compulsory licenses. Now, members of the panel, this would render
Councillor, can I interrupt you? So I think there's a difference between a subsequent agreement and a waiver, right? And I think that the ministerial declaration could be better characterized as a waiver. And that doesn't mean that it is rendered void. It's still very much in place, but it cannot be the basis of a substantive claim as you claim to bring under Claim 3.
Madam Panelist, we submit that the 2022 ministerial decision here is not simply a waiver, but comprises several things, such as the clarifications as well. As we see from paragraph 3 of the 2022 ministerial decision, it states to provide clarifications and a waiver. So what we submit is that paragraph 3b is the waiver of Article 31F, and paragraph 3a, c, and d are clarifications on the remaining obligations under TRIPS Article 31. Now, in this way,
Council, excuse me, if it clarifies an obligation under the TRIPS, why didn't you bring a claim directly under the TRIPS? If it's just a clarification, it is not a covered agreement.
Mr. Panelist, to clarify, that is because paragraph 3c is not an obligation that ordinarily arises under TRIPS Article 31. It only arises in the situation of the 2022 ministerial decision. So it is in this specific situation that this obligation arises. Further, we note that the TRIPS agreement, the 2022 ministerial decision itself refers to the TRIPS agreement. And in this way, even though the terms of reference—
Council, I think we heard you enough on this point. Why don't you proceed with your argument?
Thank you, Mr. Panelist.
But can I, for that purpose, ask you a very simple for you question? Because you started out saying that you will explain how the production was legal and what legal consequences flow from that. But you are arguing claim 1 at the moment. Is that correct? Or are you on claim 3 or all 3 at once? That would help me at least to understand your argument if you tell us which claim of violation of a WTO agreement you are presently arguing, and where therefore the compatibility of the production with the ministerial decision comes in. Thank you.
To clarify, members of the panel, we submit that the lawfulness of the vaccines is a preliminary issue to all the 3 claims, because the lawfulness of the vaccines would determine whether or not the enforcement proceedings should be allowed to take place. We submit because the vaccines were lawful, there was no infringement of intellectual property rights, and Versania was wrong to have enforced their rights in this case. So let me first—
So can you please explain why the vaccines being lawful is a preliminary issue for claim 2?
I suppose you mean the claim under GATT, Madam Panelist. Yes, Madam Panelist, we submit that it is relevant because this would determine whether the vaccines were rightfully or justifiably enforced against under GATT as well. So it would determine whether they constitute traffic in transit.
But I assume you're coming to that
Yes, my co-counsel will address that.
So let's perhaps proceed.
Yes, Mr. Panelist. So we submit that in this, with the Executive Order 46 falls within the scope of the 2022 ministerial decision as is prescribed in paragraph 1, that it must be to the extent necessary to address the COVID-19 pandemic. Now, members of the panel, the term necessary has been interpreted before under GATT Articles 20B and D, and we have seen in cases such as Korea Beef, EC Asbestos, and Colombia Ports of Entry that this comprises a balancing test of several factors.
Counsel, if we look at the TRIPS waiver, should we just use the interpretation of the term necessary that is in the GATT for the TRIPS waiver, while the context of what the term arise in this waiver and the purpose of the waiver are different from the GATT. So could you please elaborate on that?
Yes, Mr. Panelist, 2 points to that. Firstly, we note that in recital 2A of the TRIPS preamble, it purports to build on the GATT itself. So that is why we draw reference primarily from GATT. However, we also do need to take into account the context of the 2022 ministerial decision. And that let me bring you now to that and how that plays into the test. So, Mr. Panelist, we note that in paragraph 3 of the 2022 ministerial declaration, which accompanies the decision, it states that this pandemic has highlighted the importance of working towards enhancing timely, equitable, and global access to safe, affordable, and effective COVID-19 vaccines. As such, Mr. Panelist, what we see here is that access to vaccines is an important context of this balancing test. Now, very quickly, members of the panel, this test is a balancing test of several factors, such as the relative importance of the aims, the significance of the contribution of the measure to those aims, the trade restrictiveness of the measure, and whether there are any reasonably available alternatives. So bearing in mind this context, we now turn to the factors of this test. On the first factor of the relative importance of the aims, members of the panel, Arion aimed to save lives with Executive Order 46 by providing affordable access to vaccines. This is in line with the aforementioned intentions of the 2022 ministerial decision, and the appellate body in Brazil retreaded tires has held that few interests are more vital and important than protecting human beings from health risks. As such, Executive Order 46 serves an important goal. Turning now to the significance of the
So around 80% of the population in your country has already been fully vaccinated, which removes the possibility of severe cases. So why are these vaccines so important to save human lives then?
Yes, Madam Panelist. So studies have shown the importance of extra inoculation towards the maintenance of high levels of immunization, as seen in Arion and Boutica.
Studies are these?
One such study besides Arion's is the one by Harvard researchers and Israel's Claret Research Institute.
And why are they relevant for us today? What sort of persuasive value do they have?
Members of the panel, we submit that this is one of the studies which Arion has set its level of protection, which it is allowed to do per EC Asbestos. Even if this panel finds that this study is a divergent opinion, it is a qualified one. And following from EC Asbestos, Arion should be allowed to take.
Excuse me, counsel. If we wanted to ask, for example, the World Health Organization for their opinion on this issue, is this something as a panel we have the power to do? And what would be the legal basis for doing so?
Yes, Mr. Panelist, we do note that in EC Asbestos, the appellate body there did refer to WHO reports to determine whether to accept France's level of protection with reference to the dangers of asbestos. So this is something this panel may choose to do as well. However, in this case, we do note that the
Counsel, if we wanted to ask the opinion of an expert, is there a provision on this matter in the covered agreements?
Mr. Panelist, under DSU Article 11, this panel is able to make an objective assessment of the facts, and under this article, we submit that the WHO may be invited to, a WHO expert may be invited to give evidence on this fact. Now, members of the panel, let me continue to show you why this was so important in Arion. So as we have mentioned, the studies did show that extra inoculation, which was the vaccines produced here, was important towards maintaining high levels of immunization and reducing further risk of COVID-19. Particularly in July last year, when Executive Order 46 was issued, we saw from the WHO epidemiological update that it was the 4th consecutive week of an increase in the number of COVID-19 infections globally. What this indicated was that despite the fact that more than half the world at the time were considered fully inoculated, we may not yet be out of the woods with COVID-19.
Excuse me, counsel, but Isn't Ariane also the production and supply of this is on a commercial basis and by private distributors? So, I mean, isn't there a profit motive about this? And why should it be necessary if there's a commercial incentive on all this?
Madam Panelist, 2 points to that. Firstly, that ANCOP may have earned some profit is not antithetical to the idea that it was still necessary, because profit is necessary for companies to continue their development. Secondly, the commercial distribution in this case was because, as we see from case paragraph 6, Ariane had already diverted funds from its disaster mitigation budget in order to set out the stringent campaign comprising inoculation, quarantining, and testing to combat the COVID-19 pandemic thus far. Unfortunately, Ariane, as a developing country, was not able to afford to continue to provide these vaccines for free. And it is for this reason that we instead chose to provide access through commercial means, but to keep it at an affordable level. Now, members of the panel, in light of the context at the time that we saw the
Council, you say you want to provide vaccines at affordable price, but isn't it the case that both your country and Boutica were very well able to afford the vaccines from Versania to vaccinate their entire population?
Mr. Panelist, as I mentioned in Ariane, this was the result of already diverting funds from our limited budget. We note that in Ariane, we have a GNI of only $4,000. And while Boutica is supposedly an upper middle income country, by World Bank standards, this only means a GNI of between $4,000 to $12,000. In light of this, members of the panel, if booster shots were intended to overall be a long-term consequence, this was not something that, at least for Ariane and perhaps for Boutica as well, would be affordable in the long term. As such, members of the panel, we submit that in the context at the time that we were at risk of, that there was a risk of resurgence, that at the time, these booster shots were the best way forward to ensure that we would be protected from such health problems, and in light of the global cooperation to combat the COVID-19 pandemic, we also accepted that Boutica would find it necessary to receive these vaccines, as we know they are a developing country and have limited manufacturing capacity of their own. As such, members of the panel, we submit that Executive Order 46 was necessary to address the COVID-19 pandemic in order to keep vaccines affordable and to continue access to booster shots for both populations. Now, members of the panel, accordingly, we submit that Executive Order 46 is a valid compulsory license under the 2022 ministerial decision. Let me now bring you to the claim under paragraph 3C, and we submit here that the seizure of the vaccines constitutes importation under paragraph 3C. If I may refer you to paragraph 3C itself, specifically the second sentence, it states that members shall ensure the availability of effective legal means to prevent the importation into and sale in the territories of products manufactured under the authorization in accordance with this decision and diverted to their markets inconsistently with its provisions, using the means already required to be available under the TRIPS agreement. Now, members of the panel, there are two issues here. Firstly, whether
Excuse me, Counsel. Just if I look at your panel request, and that's how you worded the third claim. If I look at Article 3C that you just read, the provision talks about ensuring the availability of effective legal means. But then what you seem to be complaining about is not the lack of legal means, but the seizure of the vaccines. So how do you link these two, and does your claim really fit under that provision?
Mr. Panelist, we submit that it does, because the importation here would show that there were no effective legal means, or that these means were not truly effective. So in this way, the importation would be a violation of paragraph 3C.
I have once more a much simpler question. Are you now arguing claim 3, a breach of the paragraph 3C?
Yes, Mr. Panelist.
You read out shall ensure, and well, if so, then I would have a question of what is your legal basis under the DSU for bringing that claim of violation? Because this is a panel established under the DSU, and it can only do its work on the basis of the DSU?
There are two arguments here. Firstly, as I suggested earlier, that the 2022 ministerial decision continues from the TRIPS agreement under very limited circumstances and thus comprises the TRIPS agreement as well, and in this way is a covered agreement. Alternatively, we note that the 2022 ministerial decision also refers to the Marrakesh Agreement, particularly Article 9. If this is so, it would be able to come under the review of this panel under DSU Article 1, second sentence.
1 second sentence.
Apologies, Mr. Panelist.
But does that mean you are at the top level arguing a breach of one of those provisions of the Marrakesh Agreement or the TRIPS agreement here? And if so, wouldn't it have been necessary to point that out in the panel request?
Mr. Panelist, we are submitting that this claim does come under the 2022 ministerial decision as it extends from either the TRIPS agreement or the Marrakesh Agreement. The reason why we do not submit that it was necessary to include this in the terms of empanelment is because it would not have prejudicial effect to the respondents. We note that the 2022 ministerial decision itself includes makes reference to the TRIPS agreement in paragraph 1 and the Marrakesh Agreement in its preamble. To this end, members of the panel, there would be no prejudicial effect to the respondents. Further, once again, if the 2022 ministerial decision is not enforceable, the systemic implications of that is that the 2022 ministerial decision would not be able to be used to ensure that the vaccines would be able to be transported in an efficient manner. So members of the panel, let me bring you to why we believe the 2022, the paragraph 3C serves the purpose of the 2022 ministerial decision. Specifically, we submit that in light of the 2022 ministerial declaration's focus on timely access, what the purpose of the paragraph 3C is to ensure that there are no deviations from the authorized trade route. In this case, the seizure of the vaccines was a deviation from the authorized trade route. So
excuse me for interrupting you. Just a very quick question, follow-up question to the co-panelists' question. Is there something in the ministerial decision that would support your position that you can bring a claim, a violation claim under the ministerial decision? So is there something in the ministerial decision itself?
Madam Panelist, if I may have 1 minute before I continue. Mr. Chair, if I may have 1 minute before I continue. So
you may.
Thank you, Mr. Chair. So what we submit here is that the wording of paragraph 3C itself indicates it to be a positive obligation, and it would apply here because it intends to prevent deviations from the authorized trade route. It is for this reason that we submit that importation, sale, and diversion must be read disjunctively so that they can separately constitute a breach of the 2022 ministerial decision to ensure that the full spectrum of acts that would constitute a deviation are prohibited. We further submit that seizure must constitute importation for this reason to prevent any deviations from the authorized trade route. Now, members of the panel, we further note that in the general clarifications that section 75.3 of the VCA states that any seized goods constitutes importation in Versanian law. While we understand that this is not conclusive of the interpretation here, we would like to understand why the respondent now disputes that this is indeed what they accept. As such, members of the panel, we submit that seizure constitutes prohibited importation under paragraph 3C of the 2022 ministerial decision. Now, members of the panel, to conclude.
Consort, sorry, since you still have some time, I'm still puzzled because this sentence does refer to the available legal means. So could you point us perhaps to which legal means are missing here? Because for us, the seizure is not enough. We need to point to the legal acts which are missing.
Mr. Panelist, we submit that the VCIPP and VCA, in the way that it was operated to allow the seizure of the vaccines in this case, indicates that the VCA and the VCIPP are not effective legal means in this case. Now, to conclude, We submit that Executive Order 46 was necessary to address the COVID-19 pandemic, as it provides affordable access to vaccines in both Arion and Boutica, which are developing countries. The seizure of these vaccines would constitute a breach of paragraph 3C, as my co-counsel will explain, the TRIPS and the GATT. This is even more damning because we note that adequate remuneration was paid and accepted by Xanos in this case, as can be seen from clarification, part 5, question 2. As such, members of the panel, instead of seizing the vaccines, we submit that they should have been let through, and if there were truly a breach of intellectual property rights, they should have been sued. Thank you.
Thank you. We'll now hear from the respondent.
May I?
I'm going too fast. Yeah. Please continue your reasoning. And in the meantime, and before I will give my colleague the opportunity to ask a question.
As a transition, but you are welcome to answer it. It's a question slightly detached from what we heard, but related to it. The language in 3C, which your fellow counsel argued, if it has this language, it must have legal effect. Is there similar language somewhere else in the realm of WTO rules where this was taken from, and which language is different in legal nature? And could that be explanation for the wording? Thanks.
Yes, can the members of the panel hear me? Yes, Mr. Panelist, a similar wording is found in annex of the TRIPS agreement, specifically paragraphs 3 and 4. So that is where a similar obligation arises between TRIPS and the ministerial decision. Now, members of the panel, apologies, I should have introduced myself. My name is Sean Rappa, and I represent, of course, Arion, the complainant. Now, today I will show 3 things. Firstly, that Versania has breached TRIPS Articles 41.1 because by seizing our lawfully produced vaccines, they have created a barrier to our legitimate trade. Second, I will show that under TRIPS Articles 51 and 52, Versania has also breached this obligation because they failed to require their right holder, Xanos, to provide adequate evidence of a prima facie infringement of the laws of the country of importation, which is Boutica in this case. Finally, I will show that Versania has breached GATT Article 5.2 because they failed to provide the freedom of transit for our vaccines, which qualified as traffic in transit. Now, before I turn to the first claim, let me address an earlier concern about whether the WTO can refer to WHO consultations, and this is found in Article 13.2 of the DSU, which allows panels to consult experts on scientific and technical matters. Now I turn to the first claim under TRIPS Article 41.1.
Excuse me, Counsel, before you start, I have one concern is here you complain about the seizure of vaccine which have been destroyed. So since this is an act in the past and we cannot bring these vaccines back to life, what recommendation would you like us as panel to make to the dispute settlement body?
Well, Mr. Panelist, while you are correct that very unfortunately our COVID-19 vaccines have been destroyed amidst a pandemic, whatever decision the panel makes today will have significant ramifications because after all, COVID-19 is not the first pandemic and will not be the last pandemic that this world faces. Any decision made by the panel today will affect the ability of WTO members to address future pandemics. Now, accordingly, members of the panel, let me first explain what TRIPS Article 41.1 does. TRIPS Article 41.1 requires WTO members to have enforcement procedures available to permit effective action to be taken against IP right infringing goods. However, this is qualified by the second sentence of TRIPS Article 41.1. It states that such enforcement procedures cannot be applied to create a barrier to legitimate trade. Now, our vaccines constitute legitimate trade because they were lawfully produced pursuant to the 2022 ministerial decision. This is because the term legitimate in TRIPS Article 41.1 should be interpreted to be lawful.
Counsel, on this, but I yield the floor to my co-panelists.
It's an undue honor, but I'd like to question your reading of Article 41(1). In particular, you've said it requires that there be no barriers. The wording is actually to avoid barriers. Is that the same thing? Can there be absolutely no barriers, or is it simply an intention to avoid?
Well, Mr. Panelist, while the specific obligation may be to avoid the creation of barriers to legitimate trade, we see here, of course, that the way the barrier has arisen in this case is through the perhaps normal application of Versanian laws. And so in this case, they have not avoided creating barriers to legitimate trade. They have specifically legislated for the creation of barriers when our vaccines pass through.
Okay, I still have my question. You talk about the legality of the trade, and then you refer to the ministerial decision. But why would one not need to refer to the intellectual property legislation in the respondent? And the question really goes to if under TRIPS, if we would consider trade that is inconsistent with the TRIPS, with the intellectual property legislation of a member, what would then still be left of the concept of illegitimate trade under TRIPS? What trade would then be illegitimate under TRIPS? If trade that is inconsistent with IP legislation of a WTO member would not be illegitimate.
Yes, Mr. Panelist, while the laws of the transiting country may be relevant, in this case, we have the ministerial decision, which specifically governs the lawfulness of these vaccines. And of course, this is not something that is new to Versania. They have incorporated into their own laws.
I have a question on this, but otherwise, please continue also to complete your answer. But when you speak about the legality, and you don't have to go into that because your fellow counsel has ably explained that to us, the compatibility with the ministerial decision. But if that decision is a waiver, then isn't a waiver of obligations under the WTO agreement? So meaning that in the most sweeping case, there is just no obligation under the WTO agreement. Doesn't that bring us back to some point of legal neutrality? And therefore, why can that at all be relevant beyond the question of neutralizing an obligation of the WTO agreement, which is the effect of a waiver? And please continue with your response about the relevant benchmark. Is it international? Is it WTO? Is it national? Under which national law?
Yes, of course. If I may first answer Mr. Chairperson's question. Of course, the Versania has incorporated the ministerial decision, so it's nothing new to them. However, if we accept that any domestic law, domestic IP legislation will always prevail over a WTO obligation, then the entirety of TRIPS would not even work. After all, the TRIPS and of course the ministerial decision are meant to govern how WTO members' IP laws can even function in the first place. Now, as to Mr. Panelist's question, of course, the ability of the ministerial decision to impose an obligation is only vital to the paragraph 3C claim. Here, even if the panel disagrees with my co-counsel and finds that perhaps the ministerial decision is only a subsequent agreement, it would still be relevant to determining the lawfulness of the vaccines under TRIPS Article 41(1). After all relevant parties are parties to the ministerial decision. Now, of course.
So can I take you back to when you were just answering the first question here? So is it not correct that the TRIPS agreement provides a base minimum that you have to fulfill? And then above and beyond that, countries are free to have the IP protection that they so desire?
Yes, Madam Panelist, you are correct that the TRIPS is a minimum obligations document. However, they have not fulfilled the
But
minimum obligation.
pursuant to that, then Varsania has its own laws. And then further pursuant to the principle of territoriality, it's well eligible to apply these laws to the medicines or to the vaccines when they're in its own territory. So the vaccines were in the Varsanian territory when they were seized. Is that not correct?
While patent law is governed by the principle of territoriality, of course, once again, a member state cannot insist that because of the principle of territoriality, they are able to use their domestic laws to circumvent international IP obligations. In this case, that is exactly what Varsania has done, because these vaccines, as my co-counsel has ably explained, are lawfully produced under the ministerial decision, and they have unilaterally themselves deemed otherwise. So that cannot be the case.
Counsel, if we are not with you in looking at the ministerial decision, can you justify the legitimate trade under TRIPS or under any of the covered agreements itself, under WTO covered agreement, not using the ministerial decision?
It is our position that, of course, given that there is a ministerial decision which specifically governs this, lawfulness should be taken with reference to the ministerial decision. So, Madam Panelist, you are correct that if you are not with us on that point, then we would fail on this TRIPS Article 41.1 claim. Of course, in other situations, to answer Mr. Chairperson's earlier question, there will be other goods which do not have a specific WTO document which governs their lawfulness. And because of this, these other goods would be determined by the laws of the domestic country.
So you seem to imply that the term legitimate trade should be interpreted differently when there's been a specific document on it, like here, the ministerial decision. But the TRIPS agreement is a treaty, and the terms of the treaty cannot change in different situations. So shouldn't we look at the terms legitimate trade and apply them based on the rules of the Vienna Convention and then find their meanings and then use the TRIPS waiver maybe as a tool in this exercise? So could you guide us through this exercise rather than simply relying on the TRIPS waiver?
Yes, unfortunately, we would still submit that the TRIPS waiver is the main document because, after all, it is a subsequent agreement that all relevant parties have agreed to. So they should affect the lawfulness of these vaccines when the vaccines are transiting through our different countries. After all, I would like to reiterate that they have incorporated this ministerial decision into their own laws.
Council, Article 41 has a very specific context in that those are enforcement procedures. The ministerial decision does not refer to either enforcement procedures or Article 41 or the terms legitimate trade. So then why is it still relevant in determining the meaning of legitimate trade?
Apologies, Madam Panelist, could you repeat that question?
So I understand your point that it's a subsequent agreement, but I'm not sure if it's entirely relevant in the interpretation of the term legitimate trade. And the reason for that is because the ministerial decision does not make any reference to either Article 41 or enforcement procedures, or it doesn't make any reference to enforcement procedures or even the terms legitimate trade. So why then are we looking at the ministerial decision for this very specific term in Article 41?
Yes, Madam Panelist, we must take into account the ministerial decision because of the systemic impacts if we do not. Let's say the ministerial decision specifically authorizes the production of vaccines between Aerion and Boudica. Now, if we do not take the fact that it is specifically authorized by the ministerial decision, then any transiting country like Varsania will be able to unilaterally determine that we have not complied with the decision and, of course, seize and destroy the vaccines. Now, this could not have been what WTO members intended when agreeing to this decision in the exceptional circumstances of the COVID-19 pandemic. And it is because we fall under the decision, our vaccines are lawful, and thus they have created a barrier to legitimate trade. Now,
could it be that legitimate trade in 41.1 last sentence has an entirely different meaning? Proposition number one, could it mean rather than legality under WTO rules, something more in the direction of moral normative propriety? Or alternative proposition number 2, could it mean, and I'll give you an example which is simpler than to explain, that for intercepting patent infringing imports, it would go too far to open every single container on every single ship, because that would then bring to a halt all trade.
Yes, Mr. Panelist. So certainly the term legitimate has been interpreted to include some form of justifiability, like in the panel in Canada Pharmaceuticals, but a bit in a different context under TRIPS Article 30. But of course, even if we accept that legitimate means justifiable, it cannot be that vaccines authorized by the ministerial decision meant to traded between 2 developing countries can lawfully be seized and even destroyed by Varsania. And it is in this way that, of course, even if justifiability is accepted, Varsania still has breached TRIPS Article 41. Now, if I may turn to the claim under TRIPS Article 51 and 52. So TRIPS Article 51 requires WTO members to have enforcement procedures for the suspension of IP right infringing goods by customs authorities. However, such Article 51 procedures must comply with the rest of Section 4, which includes TRIPS Article 52. This has been breached by Varsania because they have failed to require their right holder, Xenos, to provide adequate evidence of a prima facie infringement of the laws of the country of importation, which is Boudica in this case. Because they only required Xenos to prove a breach of Varsanian law, they have therefore violated the obligation under TRIPS Article 52. And TRIPS Article 52 must be interpreted in this manner, because otherwise we allow transiting states like Varsania to frustrate the transit of goods which WTO law tries to facilitate. After all, if some goods may transit through multiple transiting countries, and if every single transiting country's law is able to be applied, then this would be incredibly prejudicial to trade. We also can.
Excuse me, Counsel. If I look at footnote 13, doesn't it say that actually this could be applied to goods in transit? So shouldn't it be allowed?
Yes, Mr. Panelist, we are not suggesting that transiting countries cannot apply enforcement procedures to goods in transit. They may do so, but they must comply with the requirements under Section 4 of TRIPS. It cannot be that when a transiting country applies enforcement procedures, there are no relevant requirements or obligations governing the manner in which they can do so. Now, because one of these requirements is TRIPS Article 52, which Varsania themselves have breached, they have also consequently breached TRIPS Article 51.
Counsel, is there any relevant state practice on the enforcement by the state where the goods are in transit in applying the laws of the country of importation?
Madam Panelist, state practice in this realm actually goes both ways. So some states have seized goods and some states simply let them through. However, for the purposes of the TRIPS Article 51 and 52 claim, because Varsania is clearly a transiting country pursuant to footnote 13, and they have failed to provide adequate evidence of a breach of Boudican law, regardless of what state practices, they have failed to meet this obligation under TRIPS Article 52.
Excuse me, Counsel, you say that it's clearly in transit. It's not clear to me that it's not a country of importation. Why cannot it be a country of importation? After all, it did come into Varsania. Why would you say, where is this definition that distinguishes a country of importation and country in transit? And what are you relying on?
Certainly. So if we adopt a VCLT analysis to interpret the term import in TRIPS Article 51 and 52, we will reach the result that I have suggested. Now, we note that the ordinary meaning of import may be to simply bring in goods from another territory, according to the shorter Oxford English Dictionary, which we refer to pursuant to VCLT Article 31.1. However, elsewhere, the term import has been interpreted to be the country of final destination, such as by the World Customs Organization. So given that the ordinary meaning goes both ways, we must look at the context of import in TRIPS Article 51 and 52. And relevant to this context is footnote 13, Footnote 13 states that WTO members have no obligation to apply enforcement procedures to goods in transit. This means that the TRIPS Article 51 regime
Counsel,
Yes.
did I hear you say that the ordinary meaning goes both ways and that therefore you look at context? Is that what you said?
Apologies, Mr. Chairperson, let me clarify. The VCLT analysis is a holistic exercise, so it is not because the ordinary meaning goes both ways that we look at the context. But in any case, the context is part of the VCLT analysis. And because footnote 13 contemplates a clear difference between the terms goods in transit and import, here Bosnia is a transiting country.
I think your clarification made it worse. Do you see the test under Article 31(1) to be a test of ordinary meaning, context, object, and purpose? Is that what you're arguing? Think about that and perhaps come back to this later.
Yes, so I'll answer that question later, apologies. But because Bosnia has failed to meet this TRIPS Article 52 obligation.
Excuse me, Counsel. You were mentioning the context in Article 13 and the fact that footnote 13, differentiate between imported goods and goods in transit. But if you read footnote 13, it does not simply say imports of goods. It says imports of goods put on the market. And then if you go to Article 41, you also have a difference between, it's not merely imported goods, but it's imported goods which have entered into channels of commerce in their jurisdiction. So wouldn't the context actually point that imported goods can be either goods that enter into commerce or put on the market, as well as goods in transit? So wouldn't goods in transit essentially be one type of imported goods, and therefore the country of transit could be the country of importation?
Members of the panel, Mr. Chairperson, if I may ask for 2 more minutes.
Granted.
Now, our argument is that, of course, when reading footnote 13 with Article 51, there is a difference being contemplated. Now, if there was some overlap between the meaning of transit and import, surely the WTO members would have made it clearer instead of simply putting it into TRIPS as 2 separate terms. Now, because
doesn't it possibly go the opposite direction, if I may say, precisely because the reference in the footnote to goods in transit as a possible exception to imported goods rather than as a completely distinct category. Doesn't that go the opposite direction to your argument?
Well, another point to consider about their differentiation is, of course, we recall that footnote 13 states there is no obligation to apply enforcement procedures to goods in transit, whereas there is an obligation to apply enforcement procedures to goods which are imported. And of course, one is mandatory, one is voluntary. If there is some overlap, then surely the TRIPS Article 51 regime would not work properly. If I may now move on to the GATT Article 5.2.
One last question.
Yes.
Has a WTO panel ever ruled on the meaning of the word importation? Perhaps not in the context of TRIPS, but in any other context?
Madam panelists, no, there has not been any WTO jurisprudence on this. So I now proceed to the claim under GATT Article 5.2. GATT Article 5.2 requires that WTO members must provide freedom of transit for traffic in transit via the routes most convenient. The vaccine shipments are traffic in transit because they fall within its definition, as explained by the panel in Colombia Ports of Entry, which states that traffic in transit refers to goods whose passage over a territory constitutes only a portion of a complete journey beginning and terminating beyond the frontier of a contracting party's territory. So here, since the vaccines begin in Arion and were intended to terminate in Boudica for the purposes of GATT Article 5, Bosnia is a transiting country.
Yes, Counsel, but let's immediately jump to where it really hurts. Is the right to transit an absolute right?
We are not suggesting that the right of transit is absolute. It
I'm
is.
happy to hear that you're not suggesting that, but so where do you draw the line?
The line is very conveniently found in the next provision, GATT Article 5.3.
Before you
Explain.
before you go to 5.3, can I ask a question to something which your colleague said at the very beginning, which sounded to me that Article 5, freedom of transit, accrues only to legal trade. So my question to you is that truly your position? So if somebody produces illegally cocaine in one country and then ships it to elsewhere, transiting through a third country, is that transit country not bound by the obligations of Article 5 and limited to what Article 20 allows when it restricts that transit?
Not at all, Mr. Panelist. Of course, the freedom of transit cannot be entirely unregulated, neither can it be entirely free. So the line drawn is in GATT Article 5.3, which refers to applicable custom laws and regulations. Now, we accept that, of course, applicable custom laws and regulations may apply, but they must fall in line with Vasania's international WTO obligations. In any case, even if the panel is not with me on this point, ultimately the seizure and destruction of the vaccines must have been necessary. And it is unclear why it is necessary because there was an alternative. Vasania could have simply let these goods through to Boudica and then sue ANCOP elsewhere if they were interested in vindicating Xanos's IP rights. This would have the added benefit of ensuring that lives in Boudica were saved while also ensuring that their IP rights were vindicated. Unfortunately, what Vasania did in this case was to seize and destroy vaccine traded between developing countries amidst a COVID-19 pandemic. Now, they are
Where
protecting.
could they have sued ANCOP exactly?
Well, an example would be Aerion, but elsewhere where ANCOP has assets. Thank you, members of the panel.
And if I have it right, this time the complainants have completed their. Thank you. I'm glad I gave you the opportunity to complete. Let's now turn to the respondents. The floor is yours.
Good morning, distinguished panelists. As of this month, the WHO reports more than 13 billion doses of COVID-19 vaccines have been administered. These vaccines are the result of hard, earnest work between private pharmaceutical companies and significant efforts from WTO member governments, such as Xanos and the government of Vasania in this case at hand. Zancovac, Xanos's patented vaccine, was provided to many of us in this room, including the government of Orion, with an extremely effective vaccine that reduced the severe risk of COVID-19 by 95%. The focus now then should be on providing vaccines to those who have not been as fortunate to receive vaccines even as we speak. Therefore, the mass commercial transaction of booster doses between two countries that are sufficiently immunized does not meet the requirements of the 2022 ministerial decision on the TRIPS agreement. This leads me to the 2022 ministerial decision. However, before I start my claim, I would like to raise two preliminary concerns that we have heard from the other side. First, the complainants mentioned destruction. However, if we look to the panel's terms of reference as required under Article 6.2 of the DSU, we see no such request to ask the panel to establish the measure of destruction. Further, Mr. Crochet, you had asked earlier about whether necessity under the GATT can be transferable to the TRIPS. However, in US gasoline, the appellate body stated that the chapeau in and of itself states that nothing in this agreement shall be construed to prevent and meet the requirements of the chapeau, this agreement meaning the GATT. And this was supported by the appellate body in Thailand cigarettes, where the panel was asked to examine whether the GATT exception could apply to the TBT. Returning back to the violation.
But counsel, to do justice to their argument, I think the suggestion that was made, and I would like you to react to that, is not that Article 20 applied, but that the interpretation that was given to the concept of necessity might be of some use here. How do you reply to that?
Thank you for that clarification. If the complainants seek to use the ordinary meaning of necessity, then the panel has found that in EC geographical indications, that necessity as used under the GATT, meaning a continuum of indispensable and simply making a contribution, was applicable in the TRIPS context. However, this leads me to the violation claim of the 2022 ministerial decision. First, the panel lacks jurisdiction to hear a violation claim of a ministerial decision as it does not form one of the covered agreements under Article 1.1 of the DSU. I would like to highlight that, Madam Parwani, I believe I heard you say you agreed with the complainant that perhaps if you do find that it's a subsequent agreement under the meaning of the Vienna Convention on the Law of Treaties, Article 31.3a, that the waiver perhaps could be read into the context of the TRIPS. However, absent a cogent reason, the appellate body in EC Bananas 3 actually stated that waivers are not a subsequent agreement under the meaning of the Vienna
Senior
Convention.
counsel, you mentioned the term cogent reason. I'm not quite sure what that means. Could you clarify the meaning of this term for me, please?
Yes, Mr. Crochet. So under Article 3.2 of the DSU, the panel it asserts that the panel maintains security and predictability in the international multilateral system. However, in China rare earths, the panel did interpret the term cogent reasons as persuasive, expounded, clearly and logically convincing, meaning that absent in the reasoning of the words that I have just identified, that the panel should not depart from previous decisions which impose legitimate expectations on WTO members and provide for security and predictability. Now, we would like to contrast this waiver decision.
Counsel, do I hear you right? Are you saying that there's some sort of a binding precedent in WTO law? And under WTO dispute settlement system?
Madam Panelist, no, there is no such thing as stare decisis in international law or at the WTO. However, in the spirit of maintaining security and predictability, absent when the facts of a case follow the same legal matrix as stated in US gasoline, the panel should follow in the same reasonings. Now, this leads us to another collective waiver that actually exists under the WTO system, which is the Kimberley Process Certification Scheme for Rough Diamonds waiver. Now, this was a GATT waiver adopted by the General Council under the Article 9, 3, and 4 power. However, in paragraph 7 of the Kimberley waiver, we see explicitly that, quote, this waiver shall not preclude the rights of affected members to have recourse to GATT Article 22 and 23. Now, Madam Payosova, you asked earlier about a textual link for whether this decision creates a legally binding obligation. Well, if we look to paragraph 7 of the decision, we see such no recourse to Article 23A of the GATT. Furthermore, as I will address in my next point, but to preemptively address now, in paragraph 3C.
Small question, because you compare with the Kimberley waiver. So what does that language exactly mean, that recourse to 2223 GATT is not precluded? Or tell us what this could mean, because Article 2223 provide for different things.
Thank you, Mr. Ehring. So GATT Article 22 is members' rights to bring consultation requests, and GATT Article 23 enumerates 23A, 23.1b, and 23.1c, each providing for a different violation. The first being 23.1a is a violation complaint, 23.1b is a non-violation complaint, and 23.1c is a situational complaint. Now, under this decision, while it explicitly prohibits non-violation and situational complaints, it also explicitly leaves out recourse to bringing a violation complaint of this decision. Now, as stated by the panel earlier, this decision is a waiver. It is a waiver to TRIPS Agreement Article 31F.
Excuse me, Council. This panel hasn't said anything yet.
My apologies.
Council, could you please also respond to the complainant's argument that the chapeau of paragraph 3 of the MC decision says members agree on the following clarifications and waiver. And then subsequently, the language of paragraph C consistently includes the word shall, and it puts obligations not only on eligible members, but also all member states. So are we sure that this is, or are you sure that this is entirely only a waiver, or could it be split into different components?
Madam Parwani, you're correct that the waiver provision in and of itself is 3B. That is the waiver to Article 31F. 3C then could constitute one of the terms and conditions that govern the applicability of a waiver as required under WTO Article 9.3 and 9.4. However, as you note, paragraph 3C's second sentence, the violation claim that the complainant has brought against the government of Versania is that we have failed to ensure the availability of effective legal means. And it does state all members shall ensure. Now, while shall might certainly point to legally binding obligations, in Japan, my apologies. In EC hormones, the panel concluded that just because the SPS agreement, Article 3.1, contained the word shall, did not necessarily mean that it contained a legally binding obligation. Instead, the panel stated that we should look to the context and the facts of the case to determine whether the provision that uses such language contains legally binding obligations.
Council, so based on your reference to paragraph 7, is it the contention of the government of Versania that the enforcement of this ministerial decision is for each WTO member, is a matter for each individual WTO member?
No, Madam Panelist. To determine whether this decision applies, it first must meet the terms and conditions of the waiver under paragraph 3, and it must be in accordance with paragraphs 1 and 2.
But who determines that the conditions were met? Because it seems that the government of Versania has enacted its own laws under which essentially it considers that the vaccines do not meet the conditions of the ministerial decision.
To clarify that I have understood your questions correctly, are you asking if it is the member that determines to the extent necessary or the adoption of the decision as a whole?
No, to the extent necessary.
So it is actually up to the panel as per, if the panel deems it appropriate to exercise jurisdiction over this claim, then it would be up to the panel to make an objective assessment of paragraph 1 to the extent necessary.
So maybe to clarify my question, if the government of Versania considered that the vaccines are not consistent with this ministerial decision, shouldn't have rather brought this matter to the WTO instead of enforcing it domestically?
Madam Panelist, may I request 1 minute to answer your question and conclude my submissions?
I can grant that.
Thank you, Mr. Chairperson. Just a moment. Madam Panelist, would you mind repeating your question?
Yes, so my question is, if the government of Versania considered that the vaccines were not consistent, were produced according to the executive order that was not consistent with a ministerial decision, what was the appropriate way to claim that, to argue that? So the enforcement procedure.
Madam Panelist, IP rights are private rights, so it was up to Zanos to initiate the proper application procedures as outlined in the TRIPS agreement, as my co-counsel will speak to after. Furthermore, we would like to highlight that both ANCOP and Zanos, the pharmaceutical companies in this case at hand, had their right to a fair and justiciable hearing, and it was the government, or it was ANCOP, that refused to exercise its right of appeal. Furthermore, we notified them of the decision, and they still chose to send the vaccines, and they did not request to retrieve the vaccines, even though we stored them for 15 days in appropriate sanitary and safe conditions. And so while it is up to the domestic member to adopt the ministerial decision into its own laws, it is up to the discretion of the member to accord the level of patent protection as afforded under Article 1.1 of the TRIPS, and ensure that as long as that member meets the obligations under the TRIPS agreement and the decision, that the measure in and of itself would be WTO consistent. However, minding my time, we would like to argue that the vaccines between Orion and Boudica do not fit within this decision as, one, they are not to the extent necessary to address the COVID-19 pandemic, and two, therefore, they are not authorized by this decision. We would like to highlight that the complainants pointed to two studies, the Harvard study and an Israeli study.
Excuse me, Counsel, briefly on this before you start. The complainant came up with a test for necessity under this waiver. You briefly discussed it. You seem to disagree with the test of necessity. So what test do you suggest we should use as panel?
Well, in the decision itself, it states that the last paragraph of the decision is that nothing in this decision prejudices both members' rights to protect public health, but also the enforcement of IPR rights that allow to have these vaccines here today. Now, we do not dispute that booster doses are necessary or that members should not be allowed to take measures to protect public health. But in this case, the government of Orion and Boudica have both sufficiently provided COVID-19 vaccines for their citizens. And furthermore, going back to this study, the government of Orion and ANCOP based this transaction off of one jointly commissioned study to completely eradicate COVID-19. In the history of the WHO, only one disease has been declared eradicated, and that is the smallpox. When members decided by consensus to adopt this decision to address the exceptional circumstances of the COVID-19, as the complainant points out, we can look to the ministerial declaration. It might have been to provide equitable access, but Boudica had equitable access. Furthermore, the last paragraph of the ministerial declaration on COVID-19 pandemic preparedness states that nothing in this decision alters the rights of members.
Could addressing the pandemic not include within its ambit completely eradicating it?
Madam Panelist, the members explicitly included to the extent necessary, not simply contributing towards or to address the COVID-19 pandemic. And as the panel has recourse to Article 13 of the DSU, they may refer and consult with any scientific experts as they needed. But in Australia, that concludes my submissions, and I will pass it on to my co-counsel. Thank you very much.
Good afternoon, members of the panel. As introduced, my name is Charlotte Wong-Lebeau, and I will be addressing the claims under Article 41.1, 51, and 52 of the TRIPS agreement. Before I begin, I would like to pick up on the last point of my co-counsel, that these vaccines were not to the extent necessary to address the COVID-19 pandemic. And as my co-counsel rightly noted, that in paragraph 1 of the decision, it does set that the standard for use of this decision is to the extent necessary to address the COVID-19 pandemic. And as the complainant had noted in their opening statements, that there remain to this day many people on the planet who have yet to receive a COVID-19 vaccine. The purpose, therefore, of the ministerial decision is to provide COVID-19 vaccines to those who have yet to receive even their primary doses. The use of booster doses, while necessary to address the COVID-19 pandemic.
Counsel, if I may interrupt you, you refer to the purpose of the ministerial decision. How are we supposed to know what the purpose is? Are we just supposed to believe your statement?
We look to the text of the ministerial decision to ascertain its object and purpose. And in multiple places, it refers to the timely availability of COVID-19 vaccines, the equitable access to COVID-19 vaccines, and we may also look to the ministerial declaration which accompanied this decision for further clarification. But looking to that object and purpose, we want this decision mainly to be used for the provision of primary doses of vaccines to the extent necessary to prevent significant disease, severe disease, and death. That is the danger of the COVID-19 pandemic.
But do either of the texts make a difference between primary doses and booster doses?
No, Madam Panelist, they do not.
And are you arguing that the provision of boosters is beyond the scope of addressing the pandemic, just in the plain language?
No, Mr. Panelist, we are not. However, in the context of this transaction, it was beyond the extent necessary. Boudica, prior to entering a purchase agreement with ANCOP for doses of their generic Zancovac vaccine, were in conversations with Zanos to secure further doses of COVID-19 vaccines for their population, demonstrating at least that they were willing to engage with Zanos for further doses of Zancovac. And then, as any business decision would, they chose a cheaper option when it arrived. However, that does not mean that the affordability of these vaccines impacted the extent to which they were necessary, and therefore this particular use of the ministerial decision is not to the extent necessary to address the COVID-19 pandemic. I'd like to turn to the claims.
Can I ask you? You said earlier that not everyone in the world has had access to primary vaccines yet, and that elsewhere in the world, you stress that elsewhere, these vaccines were still needed more. Then can I ask you why you have destroyed them? And by destroying them as a country, is it possible that you violated international human rights obligations? And if so, is that of any relevance in this WTO dispute?
Thank you, Mr. Ehring. No, we have not violated any international human rights obligations. This particular dispute and the remedy that was applied were in particular reference to the IP violation that was raised by the right holder, and the proceeding that was before the Versanian Intellectual Property Board and intellectual property law in general is designed for the benefit of the right holder. In this context, where the VIP board found that these vaccines were patent infringing, we applied the remedy of seizure and destruction to the benefit of the right holder to achieve that protection, that level of protection. However, I would remind the panel that the destruction of these vaccines is not within your term of reference for this particular dispute, only their seizure and consequent importation. Turning now to the legitimacy.
I hear your point that about the terms of claims. A quick follow-up on my co-panelist's question though. Patent infringing or not, let's keep that aside, but would you agree that the destruction of COVID-19 vaccines during a pandemic constitutes a violation of presumably your state's obligation to protect the right to health?
No, Madam Panelist, we do not. Every member has the right to take measures to protect public health, and ANCOP still has 2.9 million doses of vaccines that they have produced to provide anywhere in the world. However, the particular transaction between ANCOP and Boudica pharmaceutical distributors is not supportive of the right to health. And now turning to the claims under Articles 41.1 of the TRIPS agreement, we begin with an interpretation following Article 31 of the Vienna Convention on the Law of Treaties, as this term has never previously been interpreted. Under this, we look to the ordinary meaning of the terms in their context and in light of the object and purpose of the agreement. As the panel defined the term legitimate in Canada pharmaceutical patents to be authorized or conformable to law. This is also an apt meaning for the term legitimate in the context of legitimate trade in Article 41.1, as this provision begins the section on enforcement procedures under the TRIPS agreement, demonstrating that in this context, the legitimacy or illegitimacy of trade is whether they comply with intellectual property rights and whether, therefore, enforcement procedures ought to be applied against them.
Counsel, excuse me. You seem to read legitimate as equal to lawful. But if that was really the meaning of the term that the drafters of the TRIPS intended, wouldn't they just have used the term lawful? So shouldn't legitimate have something additional?
Thank you, Mr. Panelist. No, because, excuse me, the term lawful is quite black and white in its interpretation. However, legitimate may have regard to other policy objectives and social concerns that are reflected within the text of the TRIPS agreement. And as confirmed by the panel in Australia, plain tobacco packaging, we look to Articles 7 and 8 for such principles, which include the promotion of technological innovation and indeed the protection of public health, so long as such measures do not contravene the provisions of this agreement. And in this particular case, although the complainant argues that their measure was taken to protect public health, it did contravene Article 28.1 of the agreement, which enumerates the exclusive rights of a patent. Further,
sorry, you said that legitimate trade depends on compatibility with intellectual property rights rules. Why doesn't it also include the compatibility of the restrictions with the GATT, which is a separate claim, I know, but my question to you is whether for us as panel, it is or is not necessary to resolve the whole GATT legality of the interception seizure as part of the answer to the question of whether this is legitimate trade.
Thank you, Mr. Ehring. In past practice, panels have looked to the specific agreement prior to the general agreement in making its determinations and on legal issues. This is one logical approach to interpreting the legal provisions at the WTO. And so we begin with the TRIPS context in this case as well. And although we would also like to submit to the panel that there is no conflict in this case between the TRIPS claims and the GATT claims as it concerns freedom of transit. And that is because the footnote 13 allowance allowing members to make suspension of release procedures available to right holders in concerning goods in transit, and the Article 5.3 qualification and exclusion to freedom of transit where goods fail to comply with applicable customs laws and regulations. And particularly looking to Article 51, the complainant alleges that we have violated the second part of the obligation to meet the requirements of the provisions of Section 4, most specifically of Article 52, requiring that the right holder in lodging their application provide adequate evidence of the prima facie infringement it alleges in its application. However, Zanos has met this burden and was required to meet this burden by Versania's intellectual property code on intellectual property protection, section 61.2, which enumerates precisely this, which incorporates precisely this obligation.
And so in view of the provision of paragraph 3b of the ministerial decision, should this panel look also at whether the vaccines were lawfully produced according to the legislation of Arian, and whether that constituted a legitimate trade according to the legislation of Arian and Boutica?
Thank you, Madam Panelist. We do look to the waiver provision under 3B to ascertain that indeed these vaccines were patent infringing, and that is based on the determination that these vaccines were not to the extent necessary to address the COVID-19 pandemic in Boutica, where they were being ultimately shipped. And the compliance of Orion with paragraphs 1 and 2 of the ministerial decision are both relevant for determining their authorization at law. However, while they have issued Executive Order 4622 and followed other conditions of the ministerial decision, they have not met this primary requirement that these vaccines be to the extent necessary.
May I ask then, in Versania, a determination of patent infringement, it seems, is going to hinge on an assessment of epidemiological impact of a medicine in a third party, in a third country. Is that the case?
It certainly is not a general rule of intellectual property protection in Versania. However, in this particular case, in concerning patent protected vaccines, this was a factor that the Versanian Intellectual Property Board considered in making its determination. It was not the only factor that was considered. And in providing the adequate evidence required under Article 52, Zanos did provide evidence which included Executive Order 4622, proving that these vaccines were produced using the patented process by Zanos, and therefore that their intellectual property rights were implicated. And under the allowance of footnote 13, the term country of importation under Article 52 must be read so as to allow for the country in which the application is lodged to be the country of importation. And where such an application concerns goods in transit, this must therefore be the country of transit. It would be an absurd result to expect that where such an application is lodged, a transit state and its authorities would be required to apply the laws of a different member. This would run afoul of any sovereignty principle at the WTO.
Excuse me, isn't it common procedure, for example, in contract law, that the court of one country will apply the law of another country, because there'll be a clause that although the jurisdiction will be in Paris, the law applicable will be English law. So why not with customs procedure?
Under this, where the TRIPS agreement in general, Mr. Panelist, refers to the private nature of intellectual property rights and the differences of, excuse me, before I complete my submissions, may I request one additional minute?
Granted.
The TRIPS agreement in general reflects the private nature of intellectual property rights and the different level of protection afforded to those intellectual property rights in every jurisdiction. The purpose of Article 51 is to allow a right holder to assert those rights in any WTO member, whether it be the country of importation or a transiting member. And in this case, Zanos elected to lodge its application in Versania, and we therefore applied the level of protection demanded by Versanian intellectual property law.
Counsel, are you aware of any state practice that would support your position on this?
Yes, Madam Panelist. Before the ECJ, multiple cases have allowed transiting states to apply to seize goods where they were not the country of production, nor were the country of importation, such as the Montex case and the Rolex case in the ECJ.
Sorry, Counsel. Again, are we able to look at ECJ decisions? I mean, this is the WTO. And again, can you give me authorities as to what is the persuasive nature of it?
These are facts for the panel to consider, as is any matter of domestic law at the WTO, and thereby may form context by which you make your decisions under Article 11 to make an objective assessment of the facts of this case.
Can I ask you, you referred to footnote 13 as allowance. Isn't it no obligation? And please, your colleague can answer my question. So how do you get from no obligation, which is the text or the footnote, to an allowance?
Thank you. Good afternoon, first members of the panel. Just a reminder, my name is Ian Chesney, co-counsel for Versania, and I'll be responding to Orion's claim under Article 5, Paragraph 2 of the GATT. But of course, before I do, I would like to address your question. I believe you're asking for why, an explanation for why footnote 13 under Article 51 of the TRIPS agreement ultimately is an allowance. This is because footnote 13 is there as an optional extension for protection. Footnote 13 is essentially a safeguard for members when goods are in transit, and therefore violating the intellectual property rights within the transit state that they're in, of course, as was the case here with Zanos's patent registered in Britannia. Based on the principle, of course, of territoriality, we were able to apply our laws. And as my colleague pointed out, footnote 13 has to be read as within the definition of the country of importation under Article 52. Thank you. Now, first, to respond to the complainant's claim
Sorry, counsel. I'm still not convinced that Britannia is the country of importation. Can you respond to that and what the complainants have argued?
Yes. Importation is not defined in the WTO. There is no one legal definition of importation, for example, that would cut across the whole multilateral trading system or multiple agreements. Importation has been defined in previous cases and refers generally to the action of bringing in goods from another country. But there is not one uniform legal definition.
We know that. Okay. We know that there is not a definition. But in giving meaning to the concept of importation, we should take into account that there's also the concept of transit. So how do you distinguish between importation and transit? It seems to me that you're giving a very, very broad interpretation to the concept of importation. Is there anything left that you would call transit?
Mr. Chair, it fundamentally just depends on the agreement at issue and how those obligations are implicated based on the specific agreement. So when we're talking about specifically the context of the TRIPS agreement, as my colleague pointed out, there is an allowance for application to goods in transit as per footnote 13 of Article 51. And now when we're talking in the context of the GATT, which I will be getting to, there is a different definition based on the definition for traffic in transit under Article 5.1 of Article 5. Now, with respect to the alleged violation of the first sentence of Article 5.2, I'll just begin by noting that I agree with counsel for the complainant that our freedom of transit cannot be entirely unregulated or entirely free. And that's exactly why there is an exception or a limitation to freedom of transit under Article 5, paragraph 3.
And why is 5.3 a limitation of 5.2 when it is worded as rather a separate obligation? Shall, not, and so on.
Mr. Panelist, what Article 5.3 does is it allows member states, it's permissive, it says members may route traffic in transit through their customs house in their territory, but it's on the condition that they do not subject goods to unnecessary delays or restrictions. Now, just immediately prior to that is a very specific drafted exception for cases of failure to comply with applicable customs laws and regulations. Now, Article 5.3 has not been interpreted previously, and the operative word here in this context is applicable. It's about the applicable customs laws and regulations. So it notes an exception, and applicable, which has not been defined, based on a interpretation, as my colleague outlined, in accordance with Article 31 of the Vienna Convention on the Law of Treaties. Applicable in its ordinary meaning means related or relating to. And in the context of Article 5.3, Article 5, and the GATT overall, this is related to other members' other domestic laws. And so in this case,
Counsel,
yes.
I'm going to ask you the same question as I asked the complainants. So interpretation under Article 31.1 is, according to you, you first get yourself an idea of what the ordinary meaning is, then you go to context, and then you go to object and purpose. Is that what you're arguing?
No, Mr. Chair. As the panel stated in U.S. Section 301 Trade Act and was affirmed by the appellate body in China Audio Visual, this is a holistic exercise to determine the ordinary meaning considered in its context and in light of its object and purpose. Thank you. Now, with respect to the applicable customs laws and regulations, we need to consider the fact that under the TRIPS agreement, under Section 4 of Part 3, titled Border Measures, the enforcement procedures under the TRIPS agreement are actuated through a member's customs law, applicable customs laws and regulations.
Before you proceed, I have an architectural question to be sure I follow you correctly, that you are saying 5.3 limits 5.2 and 5.3 has itself a limitation from the obligation of unnecessary restriction, which is cases of failures to comply with applicable customs laws. And you will next explain to us what this means. But do I understand correctly that in the event of failure to comply with customs law, WTO members are entitled to impose unnecessary delays and restrictions on traffic in transit, and 5.2 does not protect them? Other WTO members in such cases?
No, Mr. Panelist, the unnecessary delays or restrictions in the converse means that there may be cases when a transit state is entitled to impose necessary delays or restrictions. And in this context, because there was a failure to comply with the applicable customs laws, which of course means that we need to consider the Versania's domestic intellectual property laws, which again are actuated through their customs laws. The Orion's traffic in transit, which was IP infringing, as my colleagues outlined, as a response to that, that was a failure to comply with our applicable customs laws and regulations, and we needed to impose seizure as a necessary restriction. Now, in the context, necessity in the WTO is whenever it is found in a specific provision of the GATT, particularly in Article 20, it is always read or interpreted based on the objective that it's situated next to and it's read with. Now, in the case of Article 5.3, there isn't an objective per se specifically outlined in the text, but we do have, as I pointed out to you before, we have a very clear rationale, which is that exception for cases of failure to comply with applicable customs laws and regulations. And with respect to seizure, seizure has been defined previously in India quantitative restrictions in the context of GATT Article 11 as a limitation on an action or a limiting condition or regulation. And the appellate body has been very clear that a restriction, is very the appellate body has been very clear previously that a restriction is different from a prohibition in the context of GATT Articles 10, 11, and 13. And in this case, this panel, as my colleague outlined, is only here to debate the merits of seizure as a measure, as applied. And in this case, based on that failure to comply with our customs laws due to this traffic in transit, which was IPR infringing, we imposed seizure as a necessary restriction.
Counsel, you mentioned IP infringement, not IP infringement, not customs law violation. So are we supposed to read customs laws as also covering IP laws?
Yes, Mr. Panelist, the applicable customs laws and regulations means it's applicable to the member's domestic law. And in fact, laws or regulations was defined in India solar cells quite generally, of course, in the context of Article 20D, but quite generally to mean the domestic laws of a member. Thank you.
Also, I mean, I understand laws and regulation, but here the word uses customs, and basically the basis that the customs in Versania acted on was basically an IP law and IP legislation. So really, how do you convince us that IP legislation can qualify as the applicable customs laws and regulation?
Madam Panelist, the WTO panels are here to determine compliance with WTO obligations, or consistency with obligations, but they are not here to determine how a member needs to classify their laws ultimately. And so excuse me.
I mean, going by your reading then, the provision should have just, your reading would have been correct if the provision said applicable laws and regulations, right? But we need to give meaning to the additional word there, which is that it needs to be customs laws and regulations.
It is still applicable customs laws or regulations applicable to the other domestic law. And as I outlined with respect to the TRIPS agreement under Section 4 titled Border Measures, and a customs law is a form of border measure in the WTO. Therefore, transiting IP infringing goods engages a member's customs laws that they're obligated to have in accordance with their TRIPS obligations. Now,
So can this panel rely as a context on the relevant case law under Article 8 of the GATT? And in particular, for instance, in paragraph 3, you have a reference to customs regulations.
Madam Panelist, my research has not taken me, I haven't looked into that additional consideration in terms of the context. Thank you, though. Now, regardless, even if seizure of the vaccines in transit is inconsistent with the first sentence of Article 5.2, it's justifiable under Article 20D of the GATT because it is necessary to secure compliance with sections 48, 54, and 61.1 of the Versanian Code on Intellectual Property Protection. Now, Article 20D is an affirmative defense. Of course, the burden of proof is on the respondent to prove each element under the provisional justification of paragraph D, and then show that the measure is being applied consistently with the requirements of the SHPO. First, the Versanian Code on Intellectual Property Protection is a law or regulation within the meaning of the provision. And as the appellate body stated in previous cases, such as Mexico soft drinks, and as I said before, in India solar cells, that means the laws of a domestic member. The code is also not inconsistent with the GATT, and I'll remind the panel that the counsel for the complainant has not brought an as such violation forward with respect to an inconsistency with the laws and regulations.
On this point, is it necessary for the complainant to bring an as such complaint to prevent you from invoking Article 20D? Or can they just, now that you're invoking Article 20D, claim that your laws are not compliant with the GATT?
Mr. Panelist, they can raise it, of course, but as was stated in Columbia Textiles, the appellate body has made it clear that a responding member's law should be treated as WTO consistent until proven otherwise. So they would have to actually prove the violation, but I will respond to it with the panel's permission in that, as the appellate body has stated in previous cases, such as US 1916 Act, an as such claim, only legislation that mandates a violation of GATT obligations is as such inconsistent. So if the complainant tries to bring forward Section 54 as being a violation, for example, of Article 5, it's a discriminatory, it's a discretionary measure ultimately.
Discretionary for whom? For the applicant, the IP right holder, or for the government? So,
excuse me, Mr. Panelist, discretionary for the Intellectual Property Board to impose. Now, based on the design requirement under the test, seizure in this instance is, of course, designed exclusively for the purpose of patent protection. And considering necessity, as the appellate body laid out in Korea various measures on beef, and as counsel for the complainant pointed out, necessity is based on a holistic balancing of factors that includes the values or the common interests or values protected by the law or regulation, the trade restrictiveness of the measure, and whether the measure it makes a significant contribution to its objective. Now, I will just begin maybe by briefly responding to the alternative that was pointed out by counsel for the complainant. Of course, they raised it in the context of Article 5.3, but both in the context of Article 5.3 and 20D, that measure is simply not acceptable for us to allow these goods to transit through our state. Ultimately, we have the same situation where that engages our domestic IP laws based on the principle of territoriality.
And what about an alternative measure that would have consisted of the seizure? Yes, but a sending back of the goods.
Mr. Chair, before I respond, may I just request one additional minute to answer the question and complete my submission?
You may, because I'm very interested in the answer to the question.
Ultimately, Mr. Chair, sending the goods back as an alternative would not be acceptable. We need to consider and remember that Article 20D is about an inconsistent measure being necessary to secure compliance with a member's domestic law. And our domestic law provides very stringent IP protection based on Section 48 and the rights that are protected under Section 61. Thank you.
But I still wonder whether your domestic law that you're securing compliance with isn't itself inconsistent with Article 5.2 of the GATT, because we are arguing all this, exploring all this under the alternative where Article 5.3 would not rescue you already. That's why we're discussing Article 20. So is it at all allowed under Article 20D to stop transiting goods that are infringing IP rights in the transit territory?
Mr. Panelist, it is allowable under our law to stop goods that are infringing IP as they are entering our territory.
Not under your law, under the GATT.
Under the GATT?
Because in this scenario hypothesis, we have a breach of 5.2. 5.3 doesn't rescue you. That's why we explore 20D, and now we need enforcement of something that is GATT consistent, which, however, seems to be a transit restriction in itself that you are enforcing.
Mr. Panelist, ultimately, under the GATT, of course, if there is a violation of Article 5.2, then it has to be either justified, as I said, through the limitation we've proposed under Article 5.3, or justified under one of the general exceptions, namely 20D in this case. Now, I recognize that my time is very limited, but I will just conclude by saying that it, of course, is our position that we are also consistent, applying this measure consistently with the chapeau, as there is no discrimination or disguised restriction. And I would like to conclude by reminding the panel that the WTO is a rules-based system. We do not discount the importance of COVID-19 vaccines. However, this waiver, the MC12 decision should not be allowed to be abused. Thank you.
And thank you. Ready for the rebuttals. Complainant, the floor is yours.
Members of the panel, the respondent has suggested that the vaccines in this case were not to the extent necessary. However, let me explain why it was. The respondent has suggested that the 2022 ministerial decision focuses on the primary doses, but as Madam Panelist rightly pointed out earlier, there's no such restriction in the 2022 ministerial decision. While the respondent is correct that in Arion and Boudica, majority have received primary doses, we reiterate that Arion is allowed to determine its own level of protection, as is Boudica. As we have stated, Arion intended to maintain high levels of immunization and reduce further risk of COVID-19 in light of a risk of a global resurgence at that time. Once again, these studies did show that further inoculation could support such goals. We further note that ANCOP's vaccine in this case was $7 cheaper and would address the concerns of developing countries of affordability. We note that Arion has a GNI of only $4,000, while by World Bank standards, Boudica has a GNI of $4,000 to $12,000. Affordability was thus a key concern to ensure equitable access. Bearing in mind that Arion had already used its disaster mitigation budget to combat COVID-19 thus far, the respondent has not shown how else Arion could contribute to its campaign in light of our limitations as a developing country. Furthermore, the respondent has not refuted that adequate remuneration was paid and accepted per clarification part 5, question 2. Despite this, members of the panel, the vaccines were still destroyed. We reiterate that we are a developing country, and while it is regrettable that we could not respond within the 10 working days that we were given, we were fighting many fires, partly due to the COVID-19 pandemic, while trying to support global cooperation and the global effort towards combating COVID-19. We had hoped that the respondent was of the same mind and would have let the vaccines through. Now, members of the panel, we reiterate that the 2022 ministerial decision must be able to allow for lawful compulsory license, as in this case. It is to some extent a waiver precisely to address the exceptional COVID-19 pandemic and the systemic implication if it does not legalize compulsory licenses like Executive Order 46, is that the 2022 ministerial decision is rendered unavailable to actually address the COVID-19 pandemic. We would essentially be preferring a technical protection of intellectual property rights while putting Bhutan lives at risk. This is especially concerning when the respondent itself has incorporated the 2022 ministerial decision, so even by their own domestic laws, the compulsory license should be recognized. Under TRIPS Articles 51 and 52, the respondent argues that it would be difficult for transiting states to determine the legality of vaccines under the laws of the country of importation. We reiterate that under footnote 13 of Article 51, this is entirely optional and they do not have to do so if it appears to be too complicated. Ultimately, the 2022 ministerial decision could assist with this exercise, as well as Bhutan has also incorporated the 2022 ministerial decision. Finally, members of the panel, the respondent has argued that the seizure in this case was necessary, and while we accept that the destruction is not part of the claim itself, it suggests that there was a reasonably available alternative. The focus here is on the necessity of the measure, not whether it is simply allowed under Vasanian law. We see from clarification part 2, question 21, that no other goods were seized and destroyed. So clearly there were other solutions. For example, letting the vaccines through, or as the panelists have suggested, returning the vaccines and suing after. If there truly had been a breach of intellectual property rights, this would have been resolved privately without risking Bhutan lives. Members of the panel, the systemic implication of their reading of GATT Article 20D is that transiting countries which transport goods from landlocked states can effectively control their forms of trade and risk other countries' lives. Members of the panel, this cannot be the case. To conclude, members of the panel, the vaccines here were lawful, adequate remuneration was paid, and could have saved lives. By seizing and destroying the vaccines, the respondent has acted in violation of its WTO obligations, which it tries to justify through technicalities, to the detriment of global access to vaccines amidst a pandemic. This should not be allowed. Thank you.
Thank you for the rebuttal, the respondents.
Good afternoon, panel and members from Orion. I will respond to 3 points raised in the rebuttal by the government of Orion. Firstly, the remuneration of Xanos for the use of their patents in availing themselves of the COVID-19 decision and waiver. Secondly, the issue to necessity and the extent necessary to respond to the COVID-19 pandemic. And finally, once again, the complainant's mischaracterization of destruction as part of the panel's terms of reference for the purposes of determining what is an appropriate alternative measure under GATT Article 20D. Firstly, to the issue of remuneration. Remuneration as described under paragraph 3D of the ministerial decision is not a particular qualifier to the extent necessary use of the ministerial decision and whether or not these vaccines are lawful and authorized by law and meet the conditions of the ministerial decision. However, it does reflect that patent holders that are subject to compulsory licenses should be adequately remunerated for that infringement of their exclusive rights, which patent rights are typically a negative set of rights to be able to reject a use of their patents. Remuneration is therefore a natural procedural impact of such a compulsory license. On the issue of necessity, we look to the procedures of the Versanian Intellectual Property Board in assessing whether these vaccines actually infringed the Versanian Code on Intellectual Property Protection. We look first to the fact that under the ministerial decision, every member must adopt it into their domestic law. This subjects the ministerial decision to the domestic system of every member, and where a concern is raised, it falls under that system of law, including their desired level of intellectual property protection. Further, under Section 61 sub 3 of the Versanian Code of Intellectual Property Protection, the Versanian Intellectual Property Board takes into account proportionality and third-party interests in reaching its determinations. And I remind the panel that it is not within your role to conduct a de novo review of a domestic proceeding in this type of circumstance. And finally, to the issue of Article 20D and the available alternative measures, once again, destruction was not raised in the request for the establishment of the panel and is not within the terms of reference of this dispute. Destruction is likewise not available for consideration as part of the measure that was applied and considered for justification under Article 20D. The only measure that is being sought to be justified by availing ourselves of Article 20D is the seizure and return of the vaccines, which was raised by the complainant as the proposed alternative, would not achieve our desired level of protection as we have encoded in our intellectual property code. Thank you, panel. That concludes the rebuttal.
I think there's some seconds left, and that's why you could tell us why that would not have achieved your level of protection if the vaccines were returned to a country where they could, without the problems we are experiencing here, have been used.
Thank you, Mr. Ehring. Yes, as we know that under Article 1.1 of the TRIPS agreement, a member may adopt a more stringent level of protection, and that may apply to their entire intellectual property protection regime. And ultimately, intellectual property protection is to the benefit of the right holder. Following the decision by the Versanian Intellectual Property Board that these vaccines were infringing of our intellectual property law and of their intellectual property rights, it would not achieve our desired level of protection to the benefit of Xanos to merely send these goods back to Orion, where they could ultimately be exported again through a different route and be distributed in the market of Boudica, where they would still be IP infringing. Thank you.
Thank you. I think we've heard at length from both parties. I'm looking at the timekeepers, whether they have any message for us.
No, Mr. Chairperson, it's just time for deliberation.
Indeed, it is time for us to deliberate. Fortunately, not on who wins this case, but who wins the competition. So please wait here in the room for us to return.